Hello, everybody. My name is Juan Carlos Brando, and thank you so much for joining us in today's show with the Attorney Margaret W. Wong, who has over 46 years of experience in the immigration world, working with several families, thousands of families and cases every single year. And she is happy to help you in your immigration case. So if you have any questions, please feel free to send your question live today, and the Attorney Margaret W. Wong will be answering your questions. Let's welcome the Attorney Margaret. Hello, Ms. Wong. How are you doing today?
I'm very good, and thank you.
Thank you so much, Ms. Wong, for having us today. And well, today you are in the city of Atlanta. Today is very, very cold. Well, it was very cold in the morning. Now it's not that cold. It's very nice outside, actually. But Ms. Wong, I would like to start by talking about so many changes that are coming in this new year 2024. One of them is about the asylum applications. What happens with these asylum applications? Are they becoming more strict? Are they becoming tough with the with the asylum applications because of all of the background that people have in the past doing just asylums, just frivolous asylums, and then immigration is getting tougher. So, what are your thoughts about the changes that are coming for asylum applications?
See, let's go back to history. Before January 14th of 1994, you can file asylum anytime. So I've been in America 5 years. I need that work permit, so I file asylum. And in those days, there really is a lot more fear because China went through civil war in the 40s, and then Korea split into North and South Korea in 53. So, and then the dirty war in Latino countries, El Salvador in the 80s. And then you have those hurricanes. It's just through the years, it became worse and worse. On the other hand, as the world is, of course, now you have the war between the Palestinians and Israel just started, and then you have the Sikhs being killed in Canada. It just started. So the world is changing now more into nationalities and hate. But the asylum definition never really changed. It's still on race, nationality, a member of a special group, political opinion, and religion. So the law never changed in the past 50 years, but the world has changed. So as you read in the newspaper more and more, it's not so much fear, because of course the whole I read in the newspaper this morning and yesterday, Ecuador had, with the new president and with foreign aid, had a shut down with gangs. Ecuador used to be one of the safest country years and years ago. Now it's like descending into hell. And this morning this happened. So does that mean that people from Ecuador now can file for asylum? No, it doesn't mean that. It also have to connect with your harm. In the olden days, I still remember when I started working in the immigration area in the 70s. I mean, you can just prove like they live in a hut and they have like 10 children, and extreme poverty used to be able to win asylum. Now it can't, because it cannot be based on financial. Now asylum is not so much harder. It's just through it all, because there's so many asylum cases going based on Latino countries. So it's more like the acquiescence of the government. So for example, I was raped. I report to police. The police ignore me because the rapist is my husband, so they don't get involved in family members. Could I win asylum? So instead of saying it's a rape, we should say we have to reframe the story into like a more sexual abuse, acquiescence of the government, underfundedness of the government. It cannot be just because someone committed a criminal act that I can apply for asylum, then everybody can cry rape, So So to answer your question, it's not so much as getting harder, it's American immigration law did not change with the times. Also, nowadays, most people they really want the residencia. It's not just the work permit because it's not that hard anymore, but it's getting harder and harder to get that residencia because the number didn't increase. When I first came to America in the 60s and 70s, the numbers are about 1 million. Now it's still 1 million, but the world population have gone up like 3 times. So it is, yes, you're right, it's getting harder more because America just did not change.
Thank you so much, Ms. Wong, for this answer. And don't forget, everybody, that you can call. The phone number is 216-279-3984. 216-279-3984. Today, Ms. Wong is in Atlanta, and tomorrow she will be in the city of Columbus. And on Monday, she will be in New York. So if you want to get in touch with her, you want to make an appointment and have a talk with Ms. Wong, the number is 216-279-3984, 216-279-3984. Let's start with the questions, Ms. Wong.
Thank you.
This person is from India. I was deported back in 2013 on a non-aggravated felony. I had a 10-year ban. Can I come back or on a visitor visa? My kids are still in the United States and they are US citizens.
Okay, so if your kids are over 21 and they can file the I-130 for you, it's always easier to come in with a green card. You can always apply the tourist visa under the DS-160. It depends on how they deny. The first time, it probably 99.9% would be denied. They may deny normally on one ground on 214B, then there's no appeal. You just have to reapply after 9 months or a year. But if they deny on serious criminal record or any other reason except 214B, you can always file a waiver, a pardon, a non-immigrant visa waiver, the 192, and you don't need a qualifying relative because normally qualifying relatives for a waiver, you need parent or spouse. Now, on the criminal case, so if let's assume you have American-born children, you may or may not have a green card or American spouse. So for criminal waiver, some children qualify, depends on criminal. So definitely, I would go ahead, if you have children over 21, file the I-130 instead of waiting for the tourista visa. If you had overstayed in America, you were deported, it's very difficult. So number one, if you have children over 21, file the I-130. It'll take 6 months to 9 months for approval. Make sure it goes to NBC. You filled out the DS-260, but now on the criminal record, you really need to get, don't necessarily have to give them the indictment unless they ask, but give them the certified judgment entry to let them know what you plead guilty to. You said you were removed on a non-aggravated, so it's 10 years. So you may want to show them what the judge ruled. That's very important. Show them the NTA, show them the judge's decision. They'll help you because sometimes the American embassy interpret criminal record differently from the court because the court deportation is 237 law is a removal case. But when you're overseas now, you're coming back with a green card or non-immigrant visa. That's the laws are different. It's what we call the exclusion, the non-immigrant visa law. So it's two different standard of proof. But that's what I would do. The third thing I would do is absolutely do a FOIA for court, for immigration. Also get a copy of the 213 with the CBP. And I know I sound weird because all those numbers, but that's the only way I know how. Get that and read it because there they would show you what ICE think when they arrested you or when you were in probation and they picked you up and stuff like that. I don't know if you were removed directly from jail. I have a lot of clients, they don't want to wait in jail. They just want to leave and hopefully come back after 10 years. So these are things. Number one, get your FOIA, get certified judgment entry. See if there's any way you can vacate the criminal case. That's important. Don't expunge it. Number two, file the I-130 if the kids are over 21. If not, file for DS-160, get the tourist visa, more difficult. Number three, if you do the tourist visa, see what's the reason for denial. Sometimes they're smart. They deny on two reasons, 214B and the waiver. So I would file, and 214B and criminal. So I would file for the waiver, the 192, plus all the equity, plus explain you only want to come here to see the graduation of the kids or go to a bar mitzvah or whatever. But these are things I would do, but you need that for you. Don't assume, oh, it's not aggravated, because American embassy in India is tough. And nowadays, because of so many people coming, all the embassies are doing IB. Like Canada, you only have Montreal. China, you only have Guangzhou. But India, they're all doing it now.
Okay, thank you so much, Ms. Wong, for this answer. And yes, well, there's a lot of situations that can come through. But if you talk to the attorney, Margaret W. Wong, she will have an answer for you. So thank you so much, Ms. Wong, for sharing your knowledge. Don't forget, the phone number is 216-279-3984. Make your appointment today, and you will be able to see Ms. Wong in any of the 7 cities that she is working with the immigration field, in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And the phone number is just 1-216-279-3984, 216-279-3984. Next question, Ms. Wong, is coming from Pela. She says, she or he, I don't know, says, my I-730 has been showing ready for almost 3 weeks. I did 2 inquiries to the NVC, and both times I was told my case had been sent to my embassy. I did an inquiry to my embassy, and I was told, they told me that they haven't received
they haven't received
my case. And I'm confused because now NBC said that they sent my case to the embassy since November 2023. What can I do, Ms. Wong?
Okay, so NVC sending the case to American embassy. Some American embassy on the 730 technically is a non-immigrant visa. It's not an immigrant visa. So sometimes 730 don't even go to NVC. It go directly to American embassy, and it depends on how old that person is. And if you notice, at 730 you don't need a tax return because it's not an immigrant visa. All immigrant visa goes to NVC and then goes to American embassy. I don't know what American embassy this is. Normally, it doesn't go to NVC. So check the 730 approval, see what happened to it. Number one. Number two is show the American embassy a copy of what NVC said, because they probably didn't say it was sent there. They probably say they don't have it or something. It depends on what city you are. If you live in Ohio, we have very, very good congressional aid, or sometimes even state senators and state people help you. In Ohio, we have Sherrod Brown. We also have J.D. Vance. The both of them have very, very good people working in their office that helps only immigration matter. It doesn't hurt to go to a senatorial office or congressional office. Like in the olden days, we have Dennis Kucinich. His office is awesome. So it depends. Some people don't care, some people do, but also use them because that's what they're doing best. They do very, very good. Senators and congressional, they do better with American embassies than with Homeland Security, because senators and congressmen, they give their funding, so they better be nice to their funding senators and congressmen. On the other hand, it's in November, now it's only January, maybe give them 3 or 4 weeks, 6 weeks, but sometimes it takes 3 or 4 months for something to get to American embassy.
Ms. Wong, this person says that is in the Cameroon American embassy.
Cameroon is all these African countries are very difficult. I'm so sorry. And worse is whoever you sponsor, the wife or the children, and especially these are war-torn countries, if you never legally married them, a new law just came in a few months or 1 or 2 years ago saying that for asylum and refugee status, because of the war stuff, even if you don't have a marriage certificate, you're okay. So these are Cameroon is tough. Give them some time because Cameroon American Embassy, they're like the Wild West.
Wow,
Yeah,
that's a very
Cameroon is
tough embassy.
all those countries is very difficult.
Okay, thank you so much, Ms. Wong, for this answer. And I have a very long question coming in, and it says, "This is my first time here, but my issue is that I came to the United States with a J1 visa and got an R1 visa. Then I got denied an H1B because I did not earn my master's in a US college, but I did clinical
Okay.
pastor,
Okay.
uh, clinical pastoral education, that is hospital chaplaincy, and one must have a master's to be able to do this. Uh, when I applied for H1B, I was denied and I was asked to reapply the following year, but the cap was full. Yeah, when we applied.
Okay. I don't know why you want the H1B unless you want to switch jobs. I presume you're still working as a pastor. I would keep the R1 because 2 years after the R1, you can do the 360 and you can get a green card right away. You cannot concurrently file the green card and the 360 because they do a site visit. The fact that you already won the R1 means that they accepted your religion is the same denominational. So you need to get on paychecks for 2 years. It can even be a 1099. You don't have to be W-2. File tax return with, don't say truck driver or whatever, say religious worker. As long as you make a living wage, you need to make a wage. Like I'm a Catholic, so Catholic Church, we don't pay our people. So that's a little bit of a problem. But I don't know why you want to get an H1 unless it's a changing of the job. It seems like you're not changing. I will keep the R1, but R1 is only good for 5 years. So if you're already on tax return more than 2 years, if you still have the R1, because initial R1 should have been good for 3 years and the extension is 2, do the 360 now. As a religious worker. These are cases you may want to call me or call a lawyer or ask your current lawyer. If you were R1, I would not have changed it to an H1 because H1 religious pastor is also difficult because you're talking about the 3 ways to get R1. Vocational, professional because you have a master's, and also ministry. Because you're a pastor, you probably were already ministry. Ministry people are difficult to get H1s unless you're doing a really professional teaching job. You may want to call a lawyer. The most important thing now is, are you still in status? Because if the H1 was denied and your R1 also expired, you have a problem. But if you're still in status, do the 360 now to get that green card.
Okay, thank you so much, Ms. Wong, for your answer. Don't forget the phone number is 216-279-3984. 216-279-3984. Today, Ms. Wong is in Atlanta. Tomorrow, she will be in Columbus, Ohio. And on Monday, she will be in New York, New York. So if you want to see her, if you want to talk to her, just give us a call. The phone number is 216-279-3984. Let's go ahead with the next question, Ms. Wong. And it says, please, I want to file for a T visa, but I don't have tangible evidence. What can I do? Also, will the trafficker be contacted by law enforcement agency?
Uh, Usually, even they may or may not contact, but you need to be prepared if they contact. So, and T visa, I wonder why you say you don't have tangible evidence. What does that mean? You can write down the story and maybe talk to a lawyer or talk to me. Then we'll have to figure it out because if you never talk to a police, or if the police never picked up you don't need the police to pick up a bad guy. In fact, we have one cases where, a lot of these people, they came, uncle helped them out, and meantime they're working in a store. You don't have to be a prostitute, you can work in a store. It's supposed to be $12 an hour. They pay you like 20 hours instead of 40 hours. That in a sense is trafficking. So when you say you don't have enough tangible evidence, I don't know what you mean. And I don't know if you know what a T visa is. And don't look at just one visa, because you should look at the macro scale of your case, and then you can even do 2 or 3 visas.
Thank you so much, Ms. Wong, for this answer. And don't forget, the phone number is 216-279-3984, 216-279-3984. Next question is, uh, I filed for a cancellation based on defective NTA. Now I see the effectiveness of NTA still under discussion in Supreme Court. Will that affect my hearing in 2 months?
That's an interesting question. Actually, I I think what happened. This is a question where you may have a final order of deportation. You did a Nits Chavez motion to reopen because NT have no date and time. Now, you won the motion to reopen. Now you have IH in 2 months. I think that's your question. I won't worry, but actually, Supreme Court already decided if NT have no date and time, that's Nits Chavez. So if that's your question, absolutely, either ask for dismissal if you think you're going to lose, or ask for admin close. But I think you may win, because otherwise you won't have reopened the case. Get ready to go to trial. Don't be afraid of trials. I've been hearing a lot of questions lately. Oh, should I go, or should I just dismiss or terminate? I really think if there's any chance to win, I would go. And you have no order of deportation. So the NITS case have absolutely no bearing on your case. Prepare to go to trial, because trial is coming up. I presume your IH is coming up in 2 months. No, that law is still in existence. NTA, no date and time. So I hope your lawyer filed a 42B with merits. Merits means that you need the therapist report, you need other medical evidence and stuff like that. But you have to file a 42B. And make sure you get that work permit. So even if you lose, you already get a 5-year work permit, or even if you dismiss, you get a 5-year work permit. All work permits after October 1st of 2023 is 5 years. This is a C10 work permit for 10-year cancellation, waiver of removal, or it's a C8 for asylum, all 5 years now. So make sure you get it.
Okay, thank you so much, Ms. Wong. We have a lot of questions coming in, so I'm going to go ahead and ask the next question. This next one says, hi, Mrs. Wong. Is there a parole possibility for Venezuelans that were denied residency in Spain?
I don't understand the question. If you were denied, oh, I got it. So you probably applied for green card in Spain. It was denied. Yes, you can still do 34. I went 34A. You're still Venezuelan. The
Yeah, so
question
they only
may
need a sponsor, right?
Right. So you can still do the sponsor, but it's easy. I went 34. I went 34A. Number one. Number two is you need to do, if I were you, I would also, the question may be, now I got it. The question may be, after you come to America, can you still do asylum? Because your asylum is denied in Spain, or your residency. The answer is yes, you can still do asylum. Because on the form they ask, in other countries you were, did you ever file for asylum? Because your residency could be denied because of employment base, on marriage, on love, or whatever. Say yes if you file for asylum. If you didn't file for asylum, read the question carefully and answer them accordingly. Because the question is not were your resident denied. The question is, when you were in that country, did you apply for asylum?
Okay, thank you so much, Ms. Wong, for your answer. Don't forget, the phone number is 216-279-3984, 216-279-3984. Next question is, can anyone apply for travel document through TPS pending for re-registration and travel if
Yes.
I-131 approved but TPS pending?
If your TPS was already expired and is pending, you cannot get parole. But anytime the parole is approved, you can travel.
Okay, perfect. Thank you so much, Ms. Wong. And this next question is, hi, Mrs. Wong. I am from Dominican Republic. I entered through the border on Mexico. I have a master calendar in September this year. There's a U.S. citizen lady that we are planning to get married. I am thinking whether if getting married and she files for me or filing asylum, what is the best
Do
option for me?
both. Do both, because these are because even if you get married, you cannot file the green card directly. You need to file the I-130, and because it's like a ninth hour marriage, was anytime you're in court proceedings, you need to file the exemption. You also need Part A. It will take 9 months to 2 years for approval. So definitely file asylum if you have a great asylum story. And also concurrently file the I-130 and the A and exemption and stuff, so you have something to say. If not, during the master calendar, they're going to ask what's your relief. Just because you're married an American doesn't mean you will get a green card or work permit. I would do both.
Okay, thank you so much, Ms. Wong. And this person that is in Spain says that they applied for asylum, which was denied, and he has an expulsion order.
Good job. So don't bring it in if you get a parole paper, because at the airport, American airports are weird. Federal Express or send it into America, your friend's house. But yes, so the question is, did you apply for asylum? You say yes and denied. And during the interview, if they ask to see it, show them. If not, you're not under no obligation to show American Asylum Office your foreign asylum.
Okay, perfect. Thank you so much, Ms. Wong. Our time is up for today. It's already 1 p.m. and we know you have a lot of people waiting for you today. But thank you so much, Ms. Wong, for sharing your knowledge every single Thursday, every single Wednesday. And I'll see you next Wednesday.
Thank you. See you next Wednesday.
Thank you so much. And I hope I feel a lot better next Wednesday and not be struggling with any disease that is running around anymore in this new year 2024. Thank you so much, Ms. Wong.
Thank you, Mr. Juan Carlos.
Thank you. And for everybody who has joined us today, don't forget the phone number is 216-279-3984, 216-279-3984. Talk to the attorney Margaret W. Wong and she will have an answer for your immigration question. Don't forget, 216-279-3984. See you next time.